Good morning, ladies and gentlemen. Welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions today, and the first one we will deal with it with Bruno. It comes from Nontsikelelo. Nontsikelelo, Bruno bought a house in May through an agent called Season. And the property was actually registered, or the transaction was registered in August, but till this day, she hasn't actually moved into the property, yet the bond is actually being deducted from her account. So then the question is, what actions can she take? Because the agent has not disappeared, and the agent is not taking the calls anymore.
Sure. So the first thing we need to bear in mind is what is the agent's responsibility in situations like this. So the agent as a property practitioner, if agents are listening, as a property practitioner, you have to give professional advice to individuals, your buyers, your sellers, and the like. So in a situation like this, yes, you've done your job, you've facilitated a sale, you've connected the seller and the buyer, and it's seen through the transfer process. But as a professional, you do need to make sure that to a certain degree that the parties know where they stand. So no one's saying that you need to go give the purchaser occupation of the property, but there is an expectation that you have a conversation with the purchaser and guide them in the correct or right direction. So your failure to do so is questionable. But moving from that, though, from a liability perspective, it's not really the agent's problem whether the person can't move in, but it also depends on the contract. So maybe before we go too far as to whether it's a liability or not, look at the contract. If the contract specifies an occupation date, then you're supposed to be getting occupation from the seller. If the contract doesn't guarantee occupation, for example, if the contract makes reference to existing lease agreements, if the contract makes reference to a later occupation date, which is unusual, but say, for example, it's 6 months after date of registration or whatever the case is, so the contract would obviously be the first guiding tool for you to determine whether you're supposed to be getting occupation or not. So now I'm working on the assumption that you've read the contract and you are indeed supposed to get occupation of the property. So typically you'd call the agent and ask them to facilitate a conversation with the seller to explain why you don't have it. Agent's gone, right? Now, that the agent isn't responsible to give you occupation. They're just responsible to guide you. The seller is the one that actually carries the liability or the burden on their shoulders to make sure that the property is handed over to you, assuming that the contract says so. So your first port of call would be to confront the seller and demand that occupation be given. This is often done through the conveyancing attorneys because the conveyancers are the connection, like the agent is, the connection between the seller and the purchaser. So my suggestion is go to the conveyancers, ask them to facilitate that conversation, and then take it from there. The conveyancers would often stand for your rights because if they see that the contract requires occupation to be given to you, they will more often than not send a letter to the seller insisting. But again, it depends on the conveyancers. If the conveyancers don't assist or they throw up their hands and say, well, there's nothing we can do, then the next step would obviously be a court application. Depending on who's the property, either you're going to evict current occupiers, or you're going to compel the seller to evict current occupiers, or you're going to end up going after both. If the seller's staying on the property and you're going to evict the seller, whatever, there's a whole bunch of options. And we would normally also accompany that with a basically seeking damages from the seller, for their failure to give you occupation.
Oh, yeah. So thank you. And Nick, maybe just briefly a second leg, because I think one of the fears is that this agent has disappeared and no longer exists. Just from her perspective as the buyer, who can they actually approach? Because now they can't get a hold of the actual agent, and maybe some due diligence before when you actually deal with the agent. Where's the first place to actually check the legit, how legit is this agent? So what are some of the steps that a buyer can actually take to ensure that they're dealing with conveyances that exist, number one, agents that actually exist and are registered?
Yeah, so I think it's important to do a little bit of due diligence where you are employing someone to act as your agent in the circumstances. Depending on which industry you're looking at, there are certain things that you can do. So if you are employing a conveyancer in a particular area, a good place to look is the legal practice council for that particular division to see that the conveyancer is in fact registered, up to date with the legal practice council. This is generally quite easy depending on which legal practice council you're going to. So for the Gauteng one, which Bruno and I are subject to, it's as simple as going on a website, plugging in the attorney's name, and then it'll pop out whether that person is in fact registered for that particular division. That obviously doesn't mean that you're not going to have it's a guarantee against safeguards against a particular conveyancer, but at the very least they're registered and up to date with the legal practice council, so you know that, which is the first step. And then in respect of the agent in the circumstances, the one thing that an agent does have to have is a fidelity fund certificate, which they need to also have provided to clients when they transact with them. They're supposed to provide that particular certificate. So before you even get involved with that agent, what I would do normally is ask them for their up-to-date fidelity fund certificate for the current financial year, and they must provide that to you so that you know that they are actually registered and have a fidelity fund certificate as a safeguard in the circumstances. Again, this is not a guarantee that nothing is going to go wrong, but at the very least, you know that when you start the transaction, the agent is in good stead and can actually facilitate the transaction from the start, because failure to provide a fidelity fund certificate, failure to have one, means that they are not entitled to act as an estate agent in any particular way. So they can't facilitate such a transaction. So that's a massive red flag from this.
Absolutely. So yeah, thank you very much today, Nick.